Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to Unit 4, your final unit in the second year. So we will start at the beginning, and this is Unit 4, can't even say it, 1.1. Right, let me make myself smaller. There we go. Alright, so Unit 4, which is on crime and punishment, you have to understand the criminal justice system in England and Wales, so the CSEW. This is what the Unit 4 is about, and so 1.1 is describe processes used for lawmaking. Do not forget, this is an exam where you do not have notes. It's not like your controlled assessment where you can take notes in with you. This is a memorising exam. So this is an exam you have to memorise and prepare for. So keeping your notes very, very organised, keeping your notes highlighted, doing revision posters and revision cards is absolutely paramount for this one. The other thing you need to know about Unit 4 is it's synoptic. What that means is there will be links made throughout this unit to previous topics and units you've done from the whole of your course, Unit 1, Unit 2 and Unit 3. So going back over those materials and making sure that you know them is really helpful. What is this topic about then? It is to enable you to describe processes used for lawmaking, including the government, the judicial, including judicial precedent and statutory interpretation. So that's what this topic is about. You should have knowledge of the legislative process and the roles of the judges, so the law and what the judges do. And so what I got my students to do was to think of any campaigns or cases that had an impact on the law and led to changes in it. So we discussed many campaigns that we've done previously, like the Julie Hogg case and the double jeopardy. We looked at things like Sarah's law. We looked at the other law that came in about being able to look into potentially abusive partners. I think that's Claire's law. So we looked at lots of different campaigns that we'd done previously. For example, double jeopardy. So the McPherson report came out for Stephen Lawrence's case, Julie Hogg, where obviously Dunlop confessed in prison when he was in prison for a different crime. He wasn't able to be tried again because of double jeopardy, but they changed that because he'd confessed, and so he went into prison then for the Julie Hogg murder as well. Sarah's law, so done by Sarah Payne, and Pace was also brought in, so the Maxwell conflict case. I do recommend you looking into that case. It really helps you understand Pace was brought in because of the treatment of the suspects and how they were treated very well in the murder of Maxwell or Michelle in that case. So it's how they were treated and therefore why things should have been put in place to protect suspects, and that is known as Pace. So not particularly Unit 1, campaigns and change, comes into this, and Unit 3 about the verdicts in criminal cases, so the jury process, the judges process, etc. So number 1 then, the government processes. One way new laws happen is through Parliament. Most laws in England and Wales are created this way. It's an important part of democracy. So we discussed why. Why is it important when you are a democracy that we are able to have some influence on the laws that are made? Laws made by Parliament are called statutes or legislation. Parliament consists of the House of Commons, usually roughly around 650 MPs elected to represent their constituents. So wherever you live, you will have an MP. They go down to the House of Commons and discuss the things that are relevant within your area. The government is the party who have the majority of MPs. New law proposals usually come from the government. So the party, Labour, Conservative, whoever it is that has the most elected MPs is usually the ruling party. So if you rule in a Labour MP, as does the majority, then it's Labour government. The House of Lords, approximately 800 lords, roughly 92 are hereditary peers, so passed from parent to child, and in the past all lords were son of nobles, so dukes and barons. Another 26 are Church of England bishops, the rest are lifetime peers, so Baroness Doreen Lawrence, for example. The monarch, who approves any bill at the end of the process, so the Queen approves the bill. Basically, she can't deny it, but it's process of politeness that they do. They pass them by her so that she knows what's going on in her country. And so then I showed this clip to the students. There's many, many clips on YouTube to help with breaking down the different government processes. So sometimes watching it in a different format like a YouTube video really helps, probably why you're here watching this now with me. Government processes continued, then how does the new law come into being? So you need to know this. You need to know this for your exam. It starts by a green paper. The green paper is where the new law is proposed. And this can be anybody. This can be proposed where you think a law should come in. This is then open for public debate and consultation. So is it something people want to see change? Is it something that people want to see happen? It'll go out to public debate and consultation. If you are around the demographic that the law is relevant to, the green paper is relevant to, you are in the consultation. Does the public support the proposal? Yes, then it becomes a white paper where the laws proposed are set out more formally. So if it is something that is needed and it's the public agree and support it, then it is written up more formally. It then becomes a bill. If not, it's just dismissed and forgotten about. It then becomes a bill. So it goes from green paper to white paper to bill, which is then represented in Parliament. So then it goes to Parliament. Once in Parliament, a bill can be presented to either the House of Commons or the House of Lords, except finance bills, which must go to Commons first. Now, the process that the bill passes through is quite extensive, and I never really realised how extensive this process is. So to get a bill in order to become a law through Parliament, it has to go through these stages, and you'll see very quickly why laws take so long to pass through Parliament. For Sarah's law, for Claire's law, these, if you know anything about the Stephen Lawrence case and the Macpherson report, these things take years. This is why it takes years. So, first reading happens. This is when it's announced and an initial vote is taken in whichever House of Lords, House of Commons it's done in. Second reading, it's then open to debate. People share their views, they discuss whether they think it'll work or doesn't work, they then vote again. It then goes to committee stage. This is when a select group then study it more closely. They look into it, they look into the legislation, they then, they explore it in more detail. They look at issues and suggest amendments. It then goes to report stage. This is then when they report what they've found. And then another vote is taken on those amendments that were found. Third reading then happens. This is when the final vote is taken. These stages are then all repeated through the House of Lords. So most things go to the House of Commons. 1 to 5 is the House of Commons. It then goes to the House of Lords, who may suggest further amendments. If they do, it's then passed back to the Commons for approval. So they'll amend it. The Commons then go back through, hear the amendments, vote again. The Commons have the final say as the elected representatives. So they are the elected representatives by the democracy, so they have the final say. It then goes to royal assent, so the monarch gives their approval. This is just a formality, though, politeness. They cannot refuse the bill. And then the bill is now an act of Parliament, and so a date is then given of when it will come into effect. That is such a long process. Do I think all of that is necessary? I discussed it with my students. Some students think it's really good because it shows how thorough it is, which is excellent. You don't just want any law to pass through when it's going to affect how you can live your life within this society. But then for the announcement, the stage 1, the first reading, and then the second reading, vote again, then the third, people go away and amend it and change it, and then they vote again. That just seems a really long process. Yes, you don't want your committee researching absolutely everything if it doesn't even get passed through Parliament in the first place, but does it have to be this long drawn out? And then for it to then have to go through exactly the same process the House of Lords, and then those amendments might go backwards and forwards. So the House of Lords say to amend something, the House of Commons then amends it, but then maybe does more changes. Then it has to go back to the House of Lords, who might say we don't like those amendments, do this, and it goes backwards and forwards. But whatever it is, This is what you have to learn. You have to learn this. You have to learn the first reading, the second reading, the committee stage, etc., etc. You have to know this process and how it happens. I then did a bit of fun with my students and we had a look at petitions. Now, petitions are before they even get to green paper. Before you get to green paper, you have to see, is there a bit of public support there? So have a look on the petitions that are out there at the moment. There'll be hundreds of them. So we looked at how there's a petition to for the exams in summer to be cancelled again and go to teacher assessed grades. There's ones about everything. Have a look. If you're 18, you could even, put your, sign them, etc. But have a look. Maybe we discussed one or two of them. We discussed, do we agree with it? Do we disagree with it? And then I got my students to come up with their own. What would you change if you could? What green paper would you put out to public? What would you like to change within your society? And then we got them to share and they voted on, etc., which one that they liked. So this is something, just a bit of fun, but it gives you an idea of the green papers. You can easily set green papers up, but you have to make sure you have the support and back in there to begin with. I then got them to look into the law of stalking as their example, the Protection from Harassment Act in 1997 and the Protection of Freedoms Act in 2012. So I got them to have a look at what's been brought in, what's changing to do with stalking currently. We then recapped at least one law, so they had it in their notes and they had something specific because case studies are key. I got them to look at the Wendell Baker case for the double jeopardy as a different example from the ones that are already done as well. How would what we've done so far then look in the exam? You could get a question that says, outline briefly the process used by the government for making laws. 3 marks. So I got them to think about what would they include in this short answer, and they'd only have about 5 minutes to write it. So I got them to plan it, got them to think about it, use their notes, etc. And then I showed them this. I showed them what they could or should have written about. They should have described green paper to white paper to bill. They should have briefly explained the process. And then they should give an example of how this works. So the act and the date, so Sarah's Law, Stephen Lawrence, Pace, whatever it might be, and how it's brought to Parliament, who, by and why. So this is your 3 marks, the describe, the explain, the example, 3 marks that you would get for this one. Always use your keywords, so green paper's a keyword, first reading, that's a key word. So there's quite a lot you would have to talk about in that 5 minutes, but that's what you would need for your 3 marks. The judicial processes then, the second part of this. The purpose of this principle is to make the law an application of the law fair and consistent. So it's about making the law fair and consistent. How does it work then? When a judge is faced with a particular type of case, he or she should apply the law in the same way as previous similar cases. This means judges in the past determine the law for judges of the future. This is known as setting a precedent. Now, this is really interesting. And it's something that you looked at in Unit 3 and about how if it's and if they have to set a precedent, how much paperwork things they have to go through to make it clear what their case is. But nearly 90%, I think it may even be more, of cases are similar to previous cases. So they think, right, this is the crime I have in front of me. What happened in the previous cases? How similar are them previous cases to this one? How was that suspect treated? What was how long did they get in prison, for example? And so they follow previous rulings and previous outcomes. However, when a case is completely new, they don't know what they're doing, they don't know. So, for example, the James Bulger case with the 2 10-year-old killers, they didn't know what to do. They had no precedent to follow, so they had to create their own precedent. They had to create their own ruling for this, and then that impacted future cases. Many laws have been made in this way, and it's called common law because it makes the law in common across the country. You can't commit a crime in Scotland or Wales or, if you commit a crime in Essex and you commit the same crime in Newcastle, you can't then get treated in a different way. You have to be treated the same. Even if you're in a different law court, a different magistrates, whatever it might be, a different Crown Court, you have to be dealt with in the same fair and consistent way. And so that's what precedents are about. Our courts are in hierarchy. The decisions are made made higher up that set the precedents for the lower courts. Sorry, the timings aren't very good on this one. And I got my students to think about 3 reasons for this. 3 reasons why the decisions are made up higher in court that then come down to the lower courts. And one of the reasons that they talked about is they have more experience, they have more training. And again, you know, things always happen at the top of the hierarchy that then filter down. When a judge faces the first case of its kind and there is no precedent, then that judge must decide what to do and set the precedent. And again, I got my students to think back to Unit 3 of how will the judges then come to know about the new precedent that's been made. However, there are a couple of exceptions, isn't there always? Overruling. This happens when a higher court decides that the decision of a lower court was wrong. For example, in the case of R versus R, the marital rape case. Again, you have to know your example, so please research into this one. But this is when a higher court decides that the lower court has made the wrong decision. So it might be where a lower court has looked to a previous precedent and thought, actually, yep, the precedent's set, therefore this person is guilty or not guilty. And the higher court comes in and goes, no, that precedent doesn't work in this case. And so that's overruling. They overrule them. And that's a really clear and good one in R versus R. Basically, in this case, a husband and wife, they get separated. The husband comes back and rapes the wife. And basically, in the lower courts, you can't rape your wife because of the way that the wording of the marriage contract was. Rape, you cannot rape your own wife. What the higher court then comes in and says is rape is rape. Whether you are married or not, rape is rape. And so they overrule it. So it's a very interesting one, is that one. Second is distinguishing. This is when the judge thinks that there are significant differences in the facts of the current case. The precedent only applies if the legal issue and the facts are similar. So if a judge, in distinguishing their case from a previous case, thinks actually there's too many differences, that precedent cannot be followed in this case. And so a good example for this is the Reed versus Lyons of 1947. Basically, Reed tries to sue her company. She's in harmful waste for the Ministry of Justice or Ministry of Defence, something like that. And she basically tries to sue them for being put at risk dealing with these harmful materials. And because she was the president of a previous case where somebody that had been open to these harmful materials was able to sue them successfully. That does not work in this case because the judge overrules the cases are not similar. So check that one out. I get my students to research both examples and make specific and detailed notes or fact files in each case, and then I give an activity where I basically jumble up what happens in each of these. They have to cut them out and stick them in the right order. But you have to know overruling and distinguishing. Second part then of statutory interpretation. We've already seen that Parliament can make laws and statutes. Judges take the Act of Parliament and then decide how it should be applied to the case before them. This is normally done by senior judges in higher courts. There are 3 rules to help them do this. Now, I find these rules really interesting. You have the literal rule, the golden rule, and the mischief rule. The literal rule then, so the literal rule of the statutory interpretation by the judiciary, wow, that's a mouthful. Basically, it's exactly as it says on the tin. They take the ruling absolutely literally. This is the first rule applied by judges. They do the literal rule. Under the literal rule, the words of the statute are given their natural or ordinary meaning and applied without the judge seeking to gloss on the words or gloss over the words or seek to make sense of the statute. Basically, what does the statute say? They have to take it as it says there, the specific words that it says, and that's what they follow. Literally follow it. The golden rule is modification of the literal rule. It states that if the literal rule produces an absurdity, so an absurd conclusion, then the court should look for another meaning of the words to avoid the absurd result. Finally, it's the mischief rule. I like this one. This third rule gives a judge more discretion. Well, they should do, since they are so qualified and have such a wealth of knowledge that gives them more discretion than either the literal or the golden rule. This rule requires the court to look at what the rule was before the statute was passed in order to discover what gap or mischief, the deviance, the statute was intended to cover. The court is then required to interpret the statute in such a way to ensure that the gap is covered. Now, that does maybe not make a lot of sense. So let me explain what the mischief rule is. Basically, the statute has been put in place because of some deviance that has happened. And so they look at what it was before the statute was put in place and what it is after the statute has been put in place. And so basically, if the literal wording of the statute is for something specific, it might be that actually what they generally meant was anything within this area, anything within this deviance is still part of the law. They might specifically literally use certain words, but actually they're talking about the mischief in general rather than whatever is the literal wording that they've used. Now, what I get my students to do, and I'm going to take you over to that sheet, I get them to work through this sheet of examples. You have to know examples for these, and it helps when you know the examples as to what each of these are. So the case study example sheet I showed them is this. And so you might want to jot down some of these case studies or research them if you haven't done them in class. Whiteley and Chapel, this one is where somebody voted for somebody that had died, so they used their voters' bill to vote, even though they were dead. And so I get my students to apply the literal, the golden, and the mischief rule to that. And then I get them to think about, in this real case, which rule do they think was actually applied to this case? And so I think for that one, it was the literal rule that literally a person that has died cannot vote, so the vote didn't actually stand, or something like that. It was a very bizarre one, was that one. Sigsworth, the son murdered his mother, who did not make a will, not made a will. Who had not made a will. Doesn't sound great English. And so normally her estate would have been inherited by the next of kin. So basically the son kills the mother, but because there was no will, he then inherits her house. So again, what does the literal rule say? What would the golden rule, what would the mischief rule imply? And again, pick which one they think was the one that was used, and then I give them the answer. Adler and George, the Official Secrets Act of 1920, basically a group of people broke into a Majesty's Forces compound, and again, how the rules were applied to that one. R versus Allen, the defendant was accused of bigamy, having more than one wife. Again, how was that dealt with? Look at the language in the quotes as well. The language helps. Is that then taken literally? Is it mischief? Is it golden? Corkery and Carpenter, the defendant was riding his bicycle whilst under the influence of alcohol, and you can't be drunk in charge of a carriage on the highway. Again, how would the literal rule read that? How would the mischief, how would the golden? Cheeseman, best one, flashed at the police officers. And then London and the North Eastern Railway Co. versus Berryman. He was working on the maintenance on the railway lines and was killed. The wife tried to sue them. So I give the students the right answer about which law was actually applied in this case, which rule was applied in this case, but I get them to see if they can apply each of the three first and which one would have been the best fit for that case. Are they then guilty or not guilty? And then I give them the verdict and we discuss them from there. You might have done completely different examples, totally fine, but using examples is absolutely key for this. Right, let's hop back to here. Finally then, the exam style question. What would this look like in the exam? With reference to government and judiciary processes, that's everything in this video. How laws are made, 9 marks. What would you include? Don't forget you need both parliament and judiciary processes. So this, I get them to plan it first. what would they put in the plan, how would they get the 9 marks, and then I give them this to see if, you know, which bits have you missed off. So Parliament, Acts of Parliament, Green White Bill, stages, give an example. Judiciary processes, you've got the make the law and how again these apply. Higher courts rule and what precedents are and how precedents are set up and how the higher courts then give these to the lower courts. The precedent, to explain what it is, leads to common law. Variations or overruling, distinguishing with examples. And then finally the statutory interpretation, what it is, literal golden and mischief, and examples where time allows. So that's how you would get your 9 marks. That's basically the whole of this PowerPoint. You could, of course, get shorter questions again, specifically on the judiciary processes. You could get specific questions on precedent. You could get specific questions on the statutory interpretation. But this is obviously a 9 marks that covers all of them. They're your biggest markers that you'll get. Those are the ones you need to spend the most time for and prepare for in your exam. Hopefully you found this video useful and it's filled in a few gaps. Please don't forget to comment below if you have any questions. If you like, give me a thumbs up, and don't forget to subscribe because there's going to be a lot more videos coming your way and I do not want you to miss out. Thank you very much for watching, everybody. Bye for now.